Good afternoon, everybody. Welcome to this webinar. I would say it's lovely to see you, but that would literally be a lie because I can't see you. But I hope very much you can hear me and Camilla. So I'm Alex Lowe. I'm a Principal Associate in the Employment Team here at Mills and Reeve.
And I'm Camilla Highmoor. I'm an associate in the employment team here. I have a little side hustle in pensions as well. If anyone's interested in pensions, I'm happy to chat with them about that.
But not today, because today we are focusing on the topic of flexible working. Just a couple of quick housekeeping points before we get into the nitty-gritty. So this is a live webinar. It is being recorded. All of you, you're muted, your videos are off as a matter of course, so I'm afraid there's not much you can do about that, but we would love to hear from you. Please pop any questions you've got in the Q&A box. We'll keep an eye on that as we go through, and we'll answer them as we go along. Lastly, you will get a feedback survey at the end of this. We would love it if you could fill that in, let us know what you think, and get that back to us, please.
So we're opening up with a couple of recent headlines in relation to flexible working and examining whether it would be the new default. I think the subtitle to this slide is definitely posed as a question, because I think it's fair to say that none of us actually know where the trajectory is going with this. At the beginning of the pandemic, there was kind of a gut feeling from some people that everything was going to go to 100% remote. And it seems as though, I mean, certainly you can see here, BP is going to work from home for 2 days a week. EY is also trialling a 2 days a week model. So I think that it's moved back to more of a kind of hybrid office home working environment. I think one thing that we can certainly say, I don't know about you, Alex, but the 9 to 5 working day is certainly a relic. I'm
not sure I've ever done 9 to 5 in 10 years at Mills and Reeve.
Yeah, that would be the dream. So I think a lot of people have implemented this hybrid and kind of remote aspect to working as a kind of trial period, just to see how things are going. So I think that in general, companies are kind of looking at this as something that they are more willing to embrace than they were pre-pandemic. Certainly smaller firms, I think, are more willing than they were. Larger firms such as EY probably did have remote working in place to a certain extent, and that was where they were eventually headed, even if this has potentially accelerated that move. So in terms of the wider organisational change, I think you had a bit to say about this, Alex.
I do indeed. So we're going to look at some of the issues thrown up by hybrid working, flexible working, through the sort of prism of a couple of scenarios, and we'll work through those and talk through those over the course of the next 40 minutes or so. I mean, to set the scene, we're at a point where lots of employers are considering, you know, okay, well, how do we deal with this? We scrambled to put in place interim temporary arrangements when businesses were forced to in the circumstances of national lockdown. The issue now is, well, you know, okay, how far do we undo those? How far do we go any further? Or if we're broadly happy with where we've got to, how do we sort of formalise that and, you know, give it a degree of permanency moving forward? The key sort of legal and practical issue is whether employers are going to try to change the contractual working arrangement that's contained in the contract of employment between the employer and each individual employee, or whether they're going to proceed on the basis of effectively just granting concessions to either individual employees or you know, bodies of employees as a whole, as a matter of discretion. I think the starting point depends upon, you know, what kind of arrangement the employer actually wants to put into effect. You know, who's really driving it? Is the impetus coming from the employee? Is it coming from the employer? Because that will have a major influence on how you approach it. But the flip side of the coin is, you know, without wanting to jump straight into another cliche, it is a two-way street. There's no point in putting an arrangement in place without, you know, first testing, you know, what is it your employees want? and also what is their strength of feeling on it, because it's very easy to say, yeah, I'd like this and I'd like that, but actually how important is it, where does it fall on their scale of relative priorities? The other sort of headline issue it's worth bearing in mind, as I'm sure you're all probably alert to anyway, is the equality angle of this, because on one level it's thought that a greater degree of remote working might enable a more inclusive workplace. It might enable people to come into the workplace or stay working in roles for longer that they might have otherwise struggled with, because they can couple perhaps caring responsibilities or other responsibilities outside of the workplace with being at home. But the flip side of the coin there is, with having a two-tier workforce, with some people being in the office or on site and others off, there is scope clearly for a difference in treatment to emerge, and that needs to be carefully managed. Let's move on to our first case study.
So this is an original work of fiction. It's not based on real facts in any way. It is based on a client called Frosty Cloud. They are a mid-market tech company. They produce cloud-based software. And during the lockdown, the board became aware of the benefits of working remotely during lockdown and is proposing to implement the following working arrangements going forwards. So the first is that the software engineers should work in the office full-time. There's a need for collaboration and there are security risks in relation to working remotely on new products. And the second arrangement is that all other departments can work from the office at least 3 days a week, but can work from home 2 days a week if they wish. This is obviously going to be prorated for part-time workers. So, should Frosty Cloud implement this hybrid arrangement as a permanent change or as a discretionary change, Alex?
Well, I think the starting point is you've got to look at who's driving this. You wouldn't be trying to change contracts of employment for the software engineers because by definition, their working arrangements, as contained in their current contracts of employment, are going to stay the same. For everybody else, what the employer is really doing here is offering a concession. It's not the employer that's saying, we actively want to force people to work from home 2 days a week. Rather, it's employees saying, actually, we quite like to do this for personal reasons. So I think that intrinsically lends itself to dealing with this as a matter of a discretionary concession, rather than trying to introduce changes to the contract of employment itself. Just to sort of break this down into a little bit more detail. And it's not necessarily directly applicable to this scenario, because this is a situation which is driven sort of by the employees, but let's just consider the pros and cons, the different ways of approaching it. So, if you're trying to introduce a change to contractual terms, on one level, that's got the advantage of certainty. You're less likely to get pushback from employees, and it becomes something that both parties can rely on. Employers entitled to say this is exactly what's in your contract, and the employee gets the certainty that these are their rights in terms of working arrangements moving forward. It might also be the opportunity to introduce any extra contractual provisions that might be of use in terms of home working. So let's say as a business you're concerned about confidentiality of your business information with employees working from home. Well, maybe you might take the opportunity to beef up your confidentiality clause in the contract of employment if you're agreeing changes to that contract anyway. But you do have to look at what's involved in changing contractual terms. So assuming employees are willing to do so, you can proceed by agreement. But that there's no unilateral right to change a contract. So if as an employer you change your mind afterwards and think, well, I shouldn't agree to that arrangement, it's a case of, well, tough. It's going to be hard to undo. I think it's getting even murkier if you're actually trying to sort of force a change onto employees that they don't really want, because then you get into issues of collective consultation, a collective redundancy consultation. That is, if 20 or more employees are affected, you get into issues of, what kind of process are you going to follow to try to force employees to agree, under potentially threat of losing their job. So that is certainly worth thinking about in a lot more detail if you find yourself in that territory. But for most employers, where the impetus for, let's say, a degree of home or flexible working is coming from employees, you're not into that territory trying to force a contractual change, and it's often just simplest to say, okay, we'll have a clear policy setting out what we're minded to do. These are the parameters in which our discretion is going to operate. These are the job roles it's going to be applicable to, and we reserve the right to to update this and change this as we go through. Camilla, what do you want to comment on sort of the other sort of issues arising out of these this kind of scenario?
Yeah, absolutely. I mean, from this scenario, I suspect that, as you said, the software engineers, there's going to be very limited risks arising from them, because all you're doing is kind of depending on the terms of their contracts of employment as currently drafted, in that I assume that they are supposed to be in the office 5 days a week. Then in relation to the hybrid factor of the other departments, we'll obviously touch on the indirect discrimination aspects and other risks later in the session. I think Alex has a couple of snazzy slides on that for us. But there are, potential for indirect discrimination claims to arise. So that is to say that we need to be aware that there are potentially indirect sex, age, disability, etc. Claims that could arise from implementation of this without kind of applying brain. There's also potentially constructive unfair dismissal claims that could arise. I suspect that's unlikely. I don't know what your view on that is, Alex, but I think it would be quite difficult for an employee to claim that by implementing a hybrid working policy, especially one that appears like this one to be so discretionary, would be a fundamental breach of their contract of employment. I
think that'd be difficult, wouldn't it? Your constructive unfair dismissal risk, will principally arise if you're trying to do something like close your office entirely, where the contractual working arrangement is that the employees are meant to come in, 5 days a week, or their full hours, whatever it is, to work in that office. And in that scenario, if you have an individual employee or a small group of employees who are adamant that they want to continue working in that office environment, they don't want to become full-time remote workers, that's potentially the situation where you might find threats of constructive unfair dismissal raised. But it seems unlikely to arise in the situation where fundamentally you're making concessions to what employees want.
Absolutely, and as you said before, it is kind of employee led in this particular scenario. I think what's going to be more of an issue going forwards for Frosty Cloud is that they need to think about the practical implications of this. As you've touched on, it's now going to have a two-tiered system where some employees are hybrid, some employees are permanently in the office, and you need to kind of keep an eye on whether kind of a culture of presenteeism is to arise, and just keep an eye on who how this is going to work in practice. There's also, we have to think about how we're going to performance manage employees going forwards if they're going to be based remotely half of the week, roughly. And as you briefly touched upon it, there's confidentiality issues, data protection, and privacy and stuff that needs to be considered before this goes into being a permanent state of affairs. That said, there's also the health and safety obligations. You have the same obligations as an employer to protect your employees at home or in the office. So worth some time applying brain, doing some desk risk assessments there. One thing that I would recommend is that the CIPD have quite a good hybrid working policy on their website, which is a good kind of basis for any policy that you implement on this more discretionary basis.
Yeah, I mean, one of the other points that sometimes comes up is that employers are concerned that, you know, if they implement a policy and sort of follow that consistently over time, it creates some kind of contractual right by the back door through, you know, through the mechanism of a term being implied into the contract of employment through custom and practice. I'm not saying discount that sort of risk altogether, but yeah, I think it's that the circumstances are going to be quite extreme for that to arise. The general principle is that express written terms will always take precedence over any, you know, terms which are said to be implied and which contradict those express written terms. So I think as long as you've got a policy which makes it clear it's been dealt with as a matter of discretion, then, you know, even if that policy is followed and utilised, you know, over a number of years, that in itself, you know, should not materially increase an employer's risk.
Absolutely, and I do think that by having this kind of soft implementation approach to hybrid working, it means that you should, as an employer, bringing us swiftly onto our next slide, hopefully be able to avoid an absolute deluge of statutory flexible working requests. So this is the next section of this. Statutory flexible working, as I'm sure you all know, I don't want to teach anyone to suck eggs, but let's take it back to the basics. It was implemented a few years ago, back when, you know, the standard pattern of working was 9 till 5, Monday to Friday, you're based in the office, and it was brought in order to help the individual make an application for a different working arrangement to the rest of the employees in the company. It was never actually designed to deal with the level of flexible working requests that we have anticipated are going to come in off the back of the pandemic and remote working. I'm not sure that there has actually been a massive increase in flexible working requests that I've seen. I don't know about you, Alex. Have you seen many queries coming in about that? Not necessarily loads, but I think that's principally because, you know, a lot of employers are forestalling these by putting in place arrangements proactively to allow employees more flexible working anyway. Yeah, which is what I would recommend would be the way forwards as well. But just kind of going back to the statutory framework in terms of eligibility. There are several eligibility criteria on the screen. So an employee needs to have 26 weeks continuous employment. There is currently a consultation ongoing to see if this should be a day one right. Whether anything comes of that or not, I'm not sure. It has to be a request in writing. It needs to be a permanent change to the contract of employment. And only one request can be made in a 12-month period, which is also being consulted on at the moment to see whether you can do more than one, which I think would be quite an administrative burden for employers. And the decision period needs to take place inclusive of any appeal within 3 months. So the actual extent of this right is probably fairly limited. There's not very many there's no real teeth to this if you don't follow this. However, obviously, as we'll come to discuss, there are kind of aspects where you need to be aware of the interaction between this right and other employment rights, such as under the Equality Act and constructive unfair dismissal rights, etc. I would say that the ACAS guidance in this area is really, really helpful and really clear, and kind of gives a really practical way of dealing with flexible working requests, statutory flexible working requests anyway. And what I would always suggest is, if you get any kind of request, even if it's not in the prescribed format, if it's not written, if it's from an employee who has less than 26 weeks continuous service, it's always worth considering whether you can facilitate this request as an employer, because it does stave off other potential kind of protected characteristic type issues. It also adds to the culture of the company in general. If you have somebody that's good, you don't want to lose them just because they want a 4-day working week instead of a 5-day working week. You want to retain talent, avoid having to re-recruit, and avoid that, awful review on Glassdoor.com.
Yeah, so I think people take that with a pinch of salt, don't they? But I agree, better to have positive reviews than negative. So shall we have a look at this through the context of another case study? I should just say we do have a question in on the Q&A, but which you will answer. But we'll come back to it after finishing this section on flexible working. So this scenario too. Our employee Maxine has worked in the marketing department at Frosty Cloud for 3 years. Company implements a hybrid working policy, and then Maxine goes to her line manager Bob of Blackadder fame, for those of you of a certain vintage, and explains that, well, working from home makes it easier for her because she has caring responsibilities for her disabled son. And in reality, she gets a lot more work done, and her supervision is unaffected when she's at home. She then hands a written request to work from home full-time to her manager Bob, and this is the first such request that she's made. So let's unpick some of these issues which flow from this. Question, I suppose, first issue is, well, what should Bob do next? Which I'll take first, and then Camilla will cover some of the other legal risks of refusing this request. Well, the short answer is Bob ought to take the request seriously, and in practice, I'd recommend he treats it as a statutory request for flexible working, whether it falls strictly within the parameters or not. That's because, as Camilla has alluded to, there are, although the statutory flexible working regime, is in place, it's been there a while, employees can make requests under it. Claims for breach of it are rare. The remedies available to employees are limited, and actually the claims in legal terms are relatively straightforward for an employer to defend, because the employer just has to show that its refusal of a request was for a particular reason, but the tribunal isn't empowered to consider how whether the refusal for that reason was justified or proportionate. So that the level of scrutiny is just fairly light. So the real reason why you should take flexible working requests seriously isn't the flexible working regime per se. It's the other sort of legal and practical factors, which are relevant here. In particular, as Camilla's going to come on to explain in a little bit, the prospect of indirect discrimination claims, and the practical effect of difficulties with recruiting people, with retaining people, of treating people fairly. But bringing it back to practical steps, well, what should Bob do? Well, if it may be actually he feels in a position to grant this request straight away. But if actually he's got some reservations, he wants to understand a bit more about it, he wants to understand how it could work, he needs to sit down and discuss it with Maxine. They need to have some dialogue about it. In this respect, the flexible working guidance produced by ACAS is quite a handy guide, because in a nutshell it boils down to an employer should take these kind of steps, respond reasonably to any flexible working request, and give it genuine consideration. If ultimately the employer thinks, well, this bit's not quite going to work or that bit's not quite going to work, the employer ought to see if a compromise can be reached, explaining its position, explaining its reasons, and seeing ultimately if you can proceed by agreement. Sometimes employers simply aren't in a position to agree to everything that an employee wants, whether it's on the merits of an employee's individual request, or even if that request in itself is reasonable and possible to accommodate when viewed in isolation, because it's not fair or reasonable to agree to that employee's request, which is coming first through the door, if potentially there's another 20 or 30 or 50 employees who might make the same request but just haven't got to it soon enough. Subject to any sort of forward planning that the employer has done when it's designed its flexible working policy, and how it's planned ahead to think, well, how am I going to treat applications from employees, to deal with them on their merits, so we agree on a first come first served basis. Subject to all of that, Bob needs to sit down and explore how far this is possible to grant, and ultimately see if an agreed way forward can follow.
Yeah, absolutely. I have to say that recently I've seen more willingness on behalf of employers to come back with a counter offer of an arrangement than previously, where I think before the pandemic the knee-jerk reaction was to say, how can I say no to this? Which is quite interesting. And I think that is one of the effects of remote working in the pandemic. I think it's opened a lot of people's eyes to what is possible within different roles. Compared to previously anyway. But coming on to legal risks of refusing a request, as Alex has alluded to, the statutory flexible working regime is fairly limited in what it can do to stop employers from unreasonably declining requests. It is, I think the maximum award is 8 weeks pay in the tribunal, and as Alex said, there are very few claims that are actually brought under the flexible working statute itself. It is more kind of the broader context of refusing a request for flexible working. So I touched upon indirect discrimination claims previously. This is where a provision, criterion, or practice, a PCP, is implemented, which applies to everybody in the same way, but it has a worse effect on some members of the staff than others. So, for example, coming back to Maxine and Bob, Maxine has said that she would like flexible working to work from home because of childcare reasons. And it has been established within the employment tribunal system that childcare and kind of caring responsibilities do tend to rest on the shoulders of women in general, obviously. And so therefore, by saying that nobody can work from home, it affects women with childcare responsibilities to a far greater extent than it could potentially affect a single man. She's also brought into the fact that her son has a disability, and there's been some novel case law on associative indirect discrimination for disability, which I think Alex is going to go over in a couple of slides' time. It's quite new. It wasn't something that we were particularly alive to before this case, I think. But because he is disabled, it might mean that Maxine would be more adversely affected by a straight out no, you can't work from home than another member of staff, for example. Then there's also the risk of constructive unfair dismissal. So if Maxine is denied this flexible working request and then resigns as a result, then she may be entitled to bring constructive unfair dismissal claims. She does have more than 2 years service. The scenario says that she's got 3 years service. So that is certainly also another risk, although the hurdles for that would be quite difficult to get over, I imagine. I think, again, what I'm going to come back to is that the practical risks here are probably also something that we need to consider, although, you know, just defending discrimination claims can be extremely expensive and time consuming. You're more likely to face issues kind of in a practical sense, in that Maxine will just resign and leave, and then you've lost somebody who appears to have been doing a very good job for 3 years for the company. To recruit, it affects your culture. It affects general morale as well. Sorry, Alex, were you about to say something?
Well, it's essentially a balancing act, isn't it? You know, different employers will draw the line at different points. You know, and it depends upon the nature of the business. It depends upon their appetite for risk. You know, it depends upon, you know, fairness and consistency within the organisation. Yeah, exactly, and whether it's just possible within the context of the organisation to grant all of this, whether it's feasible. But your risk profile in legal terms for all of these potential causes of action is largely going to come down to: are you dealing with this in a fair and reasonable way? Are you treating this employee consistently with how you have treated others in the past, or are treating others now? And if not, you know, do you have a good reason for departing from what's been done before? You know, and in sort of business terms, do you have a good basis for how far you're prepared to, you know, reject, you know, the request?
Also brings us on quite nicely to the fact that there are 8 reasons under the statute that an employer can refuse a request. Obviously,
yeah, I mean,
couched in the other risks in the room.
Yeah, I mean, the context here is that, you know, under the statutory flexible working regime, if you reject a request, you simply have to cite one or more of these 8 reasons to do so. But, you know, I'll let you read these reasons, you know, in your own time. But in a nutshell, they cover just about every kind of conceivable business reason. So you can see, well, you know, it's relatively straightforward to arrive at a decision which is justifiable within the narrow scope of the statutory flexible working regime. You know, the issue is more like to be in the field of indirect discrimination, or if you're acting really unreasonably and you know, arbitrarily, a potential constructive unfair dismissal claim, I think, is where the issue lies. I mean, in practical terms, as you go through this dialogue with an employee, keep a paper trail, keep a record of the meetings you've had, the progress you've made. To the extent you reach agreement at the end, you know, set it out in writing. You know, have you know, whether it's on a trial basis or a permanent basis, make sure that's written and agreed to by both sides. If you can't agree that, you know, make sure you give the employee an outcome in writing, saying how far, you know, what we're saying, why you can't agree to their request, and they should have the right to appeal against that decision to somebody else independent from the business. So, you know, all sort of fairly, you know, standard practice things for you guys to implement.
I'd also recommend giving a few more reasons. So although you can depend on that reason, I would always put a little bit more detail in there, just so that the employee kind of understands the reasoning and the potential impact on the business as well.
Perfect. Shall we, let's just have a look at some of these sort of fairly common reasons why the employees offer up for wanting to work flexibly. I'm sure you've heard a few of these over the preceding, you know, 6 months or so. I mean, what's the point of coming to work in an empty office is a classic one. And I think on the whole, that's got less traction now. It certainly did, have a bit more to it. Maybe certainly a year ago with a national lockdown, but certainly at times earlier this year. I remember one day back in February, I felt I needed to work in the office one day. I came in, it was a grim and grey day, and there was just about no one about. I thought, wow, this is quite literally this is pointless in being here. I got what I needed in terms of physical documents and went back home to work. So, but the on the whole, if an employer is expecting employees back in the office, that's now become the default, or at least a few days a week, or the majority of the week, then it's incumbent upon each employee to play their part. And provided an employer is holding everybody to the same standard, it's not good enough for each individual employee to say, well, I'm not doing my bit, ergo that justifies my position.
Yeah, it's back to that practical management of the two-tier system, isn't it? And making sure that everyone is doing the job ultimately. My personal favourite is we've got a dog now, so I can't come in. To which, obviously, my first two questions would be, what kind of dog have you got? And can I see a photo, please? Followed quickly by, it's also not my problem, I'm sorry. It's your decision to have made, to have got a dog. And ultimately, unfortunately, our furry family members are not dependents. We don't have any obligation to them as an employer. Although I did read recently that Brewdog has paternity leave, if anyone is interested in that.
Pathetic. Yeah, but enough about my pathetic jokes. I'm more efficient at home is another one that deserves a bit closer scrutiny, because on the face of it, this might be a valid sort of reason, but it's always worth looking at how that employee is assessing their own efficiency. For a start, actually, is that self-assessment actually objectively accurate? But even if it is, at what level is efficiency being assessed? Because I know from personal experience, you can sometimes churn through certain types of work a bit quicker at home. Maybe there's you're free from distractions. You can put your headphones on. You're not talking to people so much. You're not getting interrupted so much. So on some levels, maybe efficiency would go up. But actually query whether you're doing everything you need to be doing in your role at home to the same level. So actually, if you've got responsibilities for leading a team, for managing or supervising others, for developing, for developing more junior people, or if you're at the more junior end of the spectrum, are you able to learn from others, quite so well if you're working in isolation in a silo? Are you are you in terms of external contacts, clients, multipliers, are you actually having the same level of meaningful interaction with them if you're at home more, or should you be seeing them more face to face? Are you contributing to a thriving office environment or site environment? Some of these things depend upon the scope of each individual role. It depends upon the culture of the employer, but these these other aspects of the role should not be overlooked.
Absolutely, and haven't we all started doing a few more emails in the evening? So I actually query about how much more efficient we're all being as a society. And I also read this interesting article which said that actually after about 6 months of 100% remote working, your efficiency drops right down again, to do with kind of collaborative working and needing to go into the office to see people, etc. I think the most difficult one to counter on here, on the face of it, is probably I've proved I can work from home. Because yes, that is factually accurate, we have all been working from home for the last 18 months or so, albeit with a kind of return to hybrid working in the last few months as lockdowns have eased. But I think what needs to be provided is some context behind that. So although, yes, you may well have done really well working from home, however, at the time, your customers, your suppliers, your clients, your team, your manager, your subordinates were all also working from home. So everyone was in the same boat. I think that now that, some people have come back hybrid, it makes it more difficult for you to perform your role 100% remotely in general, anyway. Again, depending upon the role.
Yeah. I mean, the other two, I relocated during lockdown, or I'm no longer able to park on site, assuming they're nothing to do with, the employer, changing things or withdrawing benefits. They're personal factors. So, the starting point is, yes, up to a degree, it will be sensible, as I'm sure you all do, to show a bit of sympathy to employees who've forced or felt compelled to make major life changes in response to the pretty challenging circumstances of the last 18 months or so. But at the end of the day, if the job is there to be done, on site, for a good chunk of the working week, now, and that's important, then then that's what the job involves. There can only be so much flex around that. And if ultimately someone's chosen to go and live in Derbyshire or Shropshire or somewhere, then maybe they need to find a job that's a bit closer to home if the commute's a problem. Yeah, well, everything's got pros and cons, doesn't it? So
and goes in the dog one.
Yeah.
Same category as the dog, I think.
Yeah.
Moving on.
Before we come on to the slide, I just want to answer the question we've had in, which in essence was asking, well, what does treating flexible working as a discretionary concession mean in practice? Well, what it means in practice is you leave the contracts of employment exactly as they are, on the basis that those contracts of employment will say something like your normal place of work is X, where you're required to be present Monday to Friday during normal business hours, or 9 till 5 or whatever. Excuse me. So that is the default. That's what's expected as a matter of contract, and what the employer is entitled to hold employees to. What you then do is you put in place a policy which sits alongside that, ideally after engagement with employees, such that it's consistent with with what they say they want and what they say is important to them, and that policy expressly makes it clear it's contractual, and it's based upon the employer's best projections, and it is subject to change and refinement as time passes, and the employer reviews how it's working. And that policy sets out, the job roles which the employer considers are open to remote working, and to what extent. It sets out the parameters of remote working that the employer is prepared to grant. It sets out the expectations that and the constraints that apply. So, for instance, and it's wise, when you're drafting this, not to couch this too narrowly. You want to make it fairly open and fairly broad to give yourself the maximum, the maximum ability to get employees back into the office if you need them. So it might say something like, you'd need to be on site, depending upon the needs of the business or depending upon client requirements. Rather than promising it's going to be, every Monday and Friday you're allowed to work from home, you might phrase it as an average over a period of time that, you'd expect on average, 2 days a week could be worked from home, something like that. So it is worthwhile having a look at some of the policies that are out there, that are publicly available, and seeing how far they fit your needs. But that is how I'd envisage it would work in practice. Let us know on the chat if that answers the question. If we've answered the wrong question or there's an extra refinement, do let us know in the next 5 minutes and we can come back to that. Thanks, Alex. Thanks, Alex. Perfect is the answer. So that's good. Good stuff.
His ego, Debbie.
Yeah. That's, it doesn't. You need a pin out to prick that, really. So in indirect discrimination, I'm going to have a rattle through this in the next 5 minutes or so. So we're coming into the home straight now. Camilla's touched upon this concept before, so I'm not going to sort of repeat exactly what the framework is. What we're looking at here is this concept that the employer has a normal way of operating, which is ostensibly something that's applied or is applicable to everybody, but in practice, it has a disparate impact upon groups who share a particular protected characteristic. So the classic example is indirect sex discrimination, where it has a particularly disparate impact upon women who, for in a lot of cases, for childcare reasons, are less able to comply with a particular way of working than men, who don't have the same level of childcare responsibilities on average across society. So let's just look at a couple of cases. The case of Hughes and Progressive Support Limited. This concerns an employee who works as a support worker for disabled adults, and the employer had basically agreed what was called a considerate hours working arrangement to accommodate her childcare for a month before withdrawing it. The crux of the battleground in this case concerned whether what the employer did amounted to a provision, criterion, or practice. In other words, was what the employer did in withdrawing this support a one-off management decision, which would not normally engage the spectre of indirect discrimination, or was it in effect a normal way of operating, a provision, a criterion, or practice applied to the employee? And to cut to the chase, although it ultimately had to go up to the Employment Appeal Tribunal, the EAT said, look, this is a PCP in the circumstances. This meets the threshold of being part of the employer's normal way of operating, how it would normally deal with this kind of thing. So, it is open for the employee to challenge through the field of indirect discrimination. The Dobson case is, again, I won't go into all the facts, but this touches upon a point which Camilla alluded to earlier in the talk, which is about the evidence that an employee might be required to produce in order to substantiate their claim. So this is the typical scenario of a female employee with some childcare responsibilities who was seeking to bring an indirect sex discrimination claim on that basis, because she said her childcare responsibilities made it more difficult for her to do all the things the employer wanted her to do, which basically was working sort of unpredictable hours. The sort of the battleground in this case was the employer said, well, the employee's not just not being able to come up with any convincing evidence that the burden of childcare in today's society falls more on women than men. So actually, she's not discharged the burden of proof on her. Her claim's got to fail. And so the relevance of this case is the EAT's pronouncement that in this kind of scenario, the employee doesn't have to sort of proactively offer up evidence about the childcare disparity in wider society. So I think where that leaves us is that the default in this kind of case is that employment tribunals should assume that where a particular employee is struggling to deal with what the employer would like them to deal with because of childcare responsibilities, employment tribunals should assume that actually that is a burden that statistically falls more on women than men, and it's not it's not necessary for the employee in that particular case to prove it. So a quite sort of sympathetic judgment from an employee perspective, and one that employers ought to be alert to. I would add that it is open to employers, if to consider, well, actually, let's look at our policy. Does it in fact have a disparate effect on men compared to women due to childcare responsibilities in our workforce? If, let's say, the employee in question is complaining about a policy, with that affects the whole of her small team, who is, that's a mixture of men and women, but actually within that team, as a matter of fact, childcare responsibilities are fairly evenly divided between the male and female members. The employer's obviously got a much better shot of refuting that general assumption and saying, look, in this particular case, our policy did not have a disparate effect. Ergo, there's no case to answer. It's always worth bearing in mind with indirect discrimination too, that even if the employee can show this disparate effect on her in particular and women generally, it won't be discriminatory what the employer has done if the employer can show what it did was a proportionate means of achieving legitimate aim. So there is still scope to justify it. And lastly, I just wanted to touch on this concept of indirect associative disability discrimination, which is a bit of a weird one, is the technical legal analysis.
Bit of a mouthful too.
Yeah, as the scope of indirect discrimination has always been understood in this country as something that applies personally to the employee. So if you look at the wording of the relevant section of the Equality Act, it explicitly provides that in order to bring a claim of indirect discrimination, the employee has got to have the protected characteristic in question themselves. However, there was our indirect discrimination legislation ultimately derives from European law. There was a case a couple of years ago in Europe where, under the sort of the European level law, one of the European courts accepted that actually indirect discrimination could apply, so that where somebody was placed at a disadvantage because of because of the protected characteristic for somebody connected with them, that would also be enough to bring them within the scope of protection. So you've got the situation here of where this was a disability case. The employee in question didn't have a disability. It was her son, she was finding it difficult to comply with what the employer wanted her to do because of the caring responsibilities for her son, not for herself. And in this case, it's only an employment tribunal decision, so it's not binding on any other employment tribunals, and it's certainly something I think that could be susceptible to appeal. But in this particular case, the employment tribunal said actually, notwithstanding the wording of the Equality Act, which on the face of it seems to preclude this type of claim, in this particular case, we're going to read extra words into the Equality Act to effectively allow this kind of claim, to allow people to bring indirect discrimination claims where they don't have the protected characteristic themselves, but they are closely associated with somebody who does. So it is a bit of a game changer. It's not really fair on employers, to be honest, if that is going to become the law, which I do have my doubts over whether that will stick, because the whole point about indirect discrimination is there's no sort of knowledge sort of defence. So it's very difficult for an employer to sort of change its policies in anticipation of what friends and family members of employees personal circumstances might be. But I think what I'm saying is, what I'm saying is as a takeaway, just be alert to the personal circumstances of employees so far as you're aware of them, and bear in mind, actually, do we want to, can we justify what we're doing if what we're doing is making life harder for somebody in connection with a protected characteristic? I would say that would be a good rule of thumb.
Absolutely. So, do we think that flexible working is going to be the default going forwards? As I said, there is the government consultation that's going on at the moment. It closes on the 1st of December 2021. There are some organisations that seem to be quite keen on this and making a lot of noise in respect to this. Pregnant Then Screwed is all over social media trying to get people to engage with this consultation process. The key proposals aren't even that groundbreaking in my view. It's to make the right to request flexible working a day one right, probably quite tricksy for employers. But as we said, you usually should be considering them anyway, regardless of whether the employee is eligible under the statutory regime. They're going to change it so that you don't need to make a formal request just for permanent changes, but for temporary changes, potentially. Employees may be able to put in more than one request in a year, quite a lot of administrative burden, I would imagine. And the 3 month time limit might be shortened. I didn't think that 3 months was overly unreasonable period of time anyway, but we'll see. And a review of the 8 reasons that seem to cover absolutely every business need. So we'll wait and see. I think we'll have an update for you in the spring update, I imagine. So tune in. I don't think that there will be any particularly groundbreaking or astronomical changes. I would imagine that what will come into place is probably more of just a modernisation of the regime to make it less kind of individualistic and more able to deal with multiple requests off the back of the pandemic. That's my view anyway. I don't know if you had any particularly strong views on this one, Alex.
No particularly strong views.
No. There is one question in the Q&A at the moment, but if you do have any more questions, keep them coming. So this is a query from Deirdre. They're moving to a norm of working from home, and the majority will work from their home anywhere in the UK, only be expected to come into the office occasionally for a team meeting once a month or quarter. Do the contracts, which currently say the place of work is the office, need to be changed to reflect actual normal place of work being home, or is it enough to have the policy alongside the existing contract?
So we can't obviously give you specific advice on exactly what you should do, of course, but I think there's a few factors to bear in mind. So I think I think what factor one is, how sort of stark is the difference going to be between what the contract of employment says and the arrangement you want to put in place in practice, because actually, if the working arrangement is going to look wholly different, to what the contracts of employment provide, I think that's more of a reason to consider a contractual change. I suppose another factor would be, how confident are you that this is going to be a permanent arrangement? If it's something that you want to see how it goes, you might have refinements to it as time goes by. You might want to tighten it or loosen it. It's not the kind of thing to be putting in on a contractual basis at this stage. Would be my thought. On the other hand, if you are committed to it, and this is the future, because maybe sites are closing right down, then dealing with it formally might be better. I mentioned earlier that in general terms, I think the risk of sort of a constructive unfair dismissal of trying to sort of force changes to the place of work upon unwilling employees. Sorry, no. What I'm getting at is, I mentioned before the risk of a constructive unfair dismissal in this situation where a policy was put in place that was sort of quite different to the written contract of employment, and employees then said, well, hang on, I've acquired contractual rights under this policy because it's operated for so long. Generally speaking, I think that risk of sort of implied contractual rights is relatively low, but this is the kind of scenario where if you have a really sort of stark difference between what a policy says and provides for, and what the contract provides for, and the working arrangements are entirely consistent with what the policy provides for, and that just becomes the default, and everybody takes their cue from it. In that kind of scenario, I think you've got a greater risk of an employee being able to successfully argue that actually they have acquired contractual rights in that way, which might be, to take that thought to its logical extension, that's a further reason actually, if you're proposing a dramatic change to to put it on a permanent basis, and explicitly change contracts. So, sorry, Camilla, you go.
I was going to say, I think for me, a lot of it would depend on whether you're closing the offices or significantly reducing them. Then I think there's more to bear in mind in relation to that, and potentially thinking about changing contracts if you physically don't have the office space to put people in their normal place of work.
Yeah. Okay. So,
any further questions? I haven't got any at the moment. It is 3:00. I don't think that there are any further questions coming in, but please do feel free to contact me or Alex going forwards. What we would really love it if you could do, please, would be to give us some feedback. There'll be a feedback form which will appear when you end this webinar. Be as brutal as you like. We're quite happy to take any feedback. Oh, there's a Q&A. Oh, thank you, Joe. Thanks. Yeah, let us know how we did and what you would like to see in the future. There's our details if you want to get in touch.
Perfect. So all that remains is to wish you a very good rest of the afternoon and indeed rest of the week. I hope that was interesting, and we look forward to seeing some of you catch up shortly.
Hopefully in person.
Hopefully in person.
At some point. Thanks, everyone.
Bye-bye, everyone. See you later.
Bye.